Good morning, everyone. Welcome again to our conference center. We always appreciate your time and your interest today in the new DIFC Insolvency Law and regulations, which in the context of DIFC laws will always be known as Law Number 1 of 2019. We have today a panel of experts that would discuss that, and I'll introduce them later. I would, however, like this opportunity just to give you a little bit of background from the DIFC's perspective of what we wanted to achieve in this particular instance, and I think what ultimately has been achieved. Just a little bit of background. And in doing so, I want to just once again revisit the DIFC legislative philosophy, go a little bit into the detail without hopefully overlapping with Adrian may say in the work that was done prior to the actual drafting of the law, and then ultimately what the law I think means for the DIFC going forward. Now, coming back to the issue of legislative philosophy, we are reticent legislators. We like legal certainty. We like for the courts to develop the thinking and sort of principles around legislation, and knowing that if you legislate too much, you ultimately you shoot yourself in the foot by creating uncertainty. So from that perspective, we look very carefully before we actually change or amend or bring in new laws. And when we do so, there's typically three reasons why we do that. The one is DIFC has aspirations as a global financial center, and as a consequence, we consistently look sort of towards best practice elsewhere, and we do benchmarking to understand whether we are indeed sort of in line with best practice elsewhere. So there's an external exercise going on quite frequently. The second thing we do is more of an internal exercise. We do, and I'm sure some of you may have participated in working group methodology, where we have working groups looking at particular aspects, and we look at what's happening in the courts, we speak to practitioners, and we look at sort of pressure points, and from that perspective, we try and alleviate it, with the overall objective of being flexible and business friendly. And then thirdly, and not really that relevant in this context, but it was consulted also from a benchmarking perspective, because we obviously look at international organizations, standard setters, etc., and typically often imposed on us if you look at sort of FATF and OECD in the current country context. So those are the other things that typically lead us to have to legislate for it. In this particular instance, it's quite clear that this piece of legislation was driven by what we saw out of a sort of a global benchmarking exercise that we asked Clifford to do for us, I think round about in the middle of 2017, and that report came out in July of 2017. And what it basically did, that it looked at DIFC within the context of other jurisdictions where insolvency and particularly debt restructuring are important topics. And those include, obviously, England and Wales, but also included places like Singapore. In 2017, if you remember correctly, I think shortly before that analysis, they came out with their own set of sort of debtor in hand and restructuring friendly legislation. So we had a very close look at that. And then in a number of other jurisdictions, whether it's the USA, the continental jurisdictions in terms of France and Germany, and going all the way to Japan. So that it was a fairly broad analysis of what's happening in the world, also looking very closely at World Bank principles, looking at EU directives and regulations, and also guidance from Insol, the Insolvency and Restructuring practitioners body. So that was sort of the background to the benchmarking exercise, and that ultimately led to the law that you see with you today. And if I sort of have to take a step back in terms of what I think we've achieved as DIFC, you need to understand that DIFC has always been, from an insolvency and a restructuring perspective, sort of a leader in the region. And a very good example of that is the Dubai World Tribunal, which is still ongoing to this day, which started in 2009. In terms of, I think, Decree 57 of 2009, the creation of that tribunal to deal with Dubai World and its subsidiaries and its restructuring and the disputes around that, which is taking place within the context of DIFC. So we've always been, at least from a regional perspective, a leader in this context. And what we've also seen over the past few years is as DIFC is now growing up. It started in 2004, so sort of 15, 16 years old. And what we are seeing is that the companies that are coming here are becoming more sophisticated. They've always been multi-jurisdictional, but the ones that are now coming and headquartering themselves here are becoming increasingly complex and more sophisticated. And just in current times, debt restructuring, debtor-in-hand proceedings or voluntary arrangements are now at the order of the day for companies in that context. And we see that as a trend that will continue. DIFC has always positioned it as a jurisdiction of substance. And what we see now within the context of economic substance regulations that are coming out, that path that we have taken, but still remaining low tax or no tax, we believe we'll see more people coming and putting their global sort of headquarters from a multi-jurisdictional perspective into the DIFC. So it was very important for us to have an insolvency law that's basically in line with global best practice. And I think that's really what we've achieved. If you look at it, how flexible it is market best practice. I'm sure Adrian will give you a fair amount of detail why I say that. But you need to understand what our objectives were, and I think we've achieved that. In terms of today's panel, we then have members of the Clifford Chance team that were involved in that, and that's Adrian, is a partner in the London office. Adrian specializes in corporate restructuring and insolvency law, and he advises sponsors, debtors, lenders, commercial counterparties, and insolvency office holders in his practice. He led this exercise together with a team. One of those team members is Nicky Reader, who's also present here today. She's also a member of their restructuring and insolvency group. Nicky will moderate the panel. And then we also have, and it's the one thing that I've neglected to mention, we have Mr. Shahab Haider. But and the one reason for that also is when we did this, not only did we do the global benchmarking exercise, there was also a fair amount of consultation bringing the drafts back to insolvency and restructuring practitioners in this jurisdiction to not only look at the sort of the global principles on cram down rights and how do you deal with, minorities in that respect, but we wanted to have it as a flexible and a practical, pragmatic approach in this jurisdiction, and as a consequence, we also have Shahab today on the panel today to discuss some of those issues. And on that note, without further ado, I'd welcome Adrian to give us his presentation. Thanks.
Good morning, everybody. Thank you very much, Jacques, for that introduction and for addressing some of the issues, the background to this legislation. As Jacques mentioned, I'm Adrian Cohen from our practice based in London. I'm very pleased to be presenting here today with the DIFC in relation to the insolvency law, and with my colleague Nicky Reader, who is part of the local team, and with Mr. Shahab Haider as well, one of the esteemed local practitioners as well, to give a sort of varied and full perspective on this legislation. Good, the slides work. As Jacques said, we will be addressing the background to this legislation and explaining the importance of the insolvency law. It won't come as a surprise to you to know that certainly from my perspective, having a workable insolvency and restructuring law in any legal regime as part of a jurisdiction is really a cornerstone to encouraging business, because foremost, I think, at the back of everyone's mind is, if things don't go so well, what are the rights of the relative stakeholders in a business? How well are they going to be treated? To what extent is their predictability in outcome? How much are their rights respected? And so all of those things are very key to any jurisdiction, and I think it's important that the DIFC has shown great leadership in ensuring that it maintains its position ahead of the curve in this respect. So a bit about the background and context. We're going to be talking about the different types of restructuring insolvency procedures which are provided for under the new law, a focus on rehabilitation, the enhanced role of restructuring professionals, and the flexible and business-friendly features of the legislation. So just to touch on the common themes, some of you here may be familiar with the sort of law reform that's been happening within the GCC, with new laws in a number of jurisdictions, including within the United Arab Emirates, within the Kingdom of Saudi Arabia, Bahrain, and other jurisdictions as well. And a number of these have very common themes, but it's not just restricted to these developments are not just restricted to this region. There's an international pattern of reform. I was just talking to Shahab earlier before coming on, and he was recently, might address this later on in the panel session, just come back from Singapore, which has also been going through a law reform process. And there are definitely distinct international trends. On the 26th of June, so really just last week or the week before, the European Union at last published the European Union Directive on preventative frameworks, which introduces for the first time common standards of insolvency law to be applied across the European Union. And of course, the UK at the present time is also subject to that European Union directive, and is proceeding as if it will be in due course. But the common themes under that European Union directive, which are reflected, if you want, in the DIFC insolvency law, is the need for a debtor in possession process, for a focus on rehabilitation, for composition procedures whereby you can deal with dissenting creditors, and also for the availability of finance during that process. In the case of the European Union, EU members have 2 years with a possible extension by a third to introduce legislation that accords with that directive. And actually, at this point in time, the United Kingdom, which has often been a pioneer of the law in this area, actually doesn't have a debtor in possession process. So there are draft proposals, and it is likely, whether or not the UK stays in the European Union, to introduce that debtor in possession process or procedure, so that it kind of meets with the common standards which are being imposed. Standing behind this legal reform is also the World Bank and other international financial institutions, and they've been pushing law reform for a long time. And again, these kind of key badges or criteria have been up there in terms of the European the law reform process. So the law that's being introduced by the DIFC has a number of these of these criteria in there. So the use of formal procedures as part of a means of allowing the debtor a fresh start, mechanism for binding non-consenting creditors, appointment of insolvency office holders as appropriate, and then predictable and efficient liquidation processes, and then accountability. So if you want, there are two things which have to be balanced. One is giving people the opportunity to have a fresh start, to go through a process of rehabilitation, to, if you want, drain away the stigma of bankruptcy. But then on the other hand, you have to balance that with accountability. So where there has been wrongdoing, then a bright light should be shined upon it, and there should be the ability to recover sums which have been salted away, or if needs be, punish people where there has been wrongdoing. The new law introduces a number of different procedures and new aspects to it. So there's a new debtor in possession procedure, which is called the Rehabilitation procedure, which includes a stay on creditor action and also a composition whereby you can bind in dissenting creditors, and then also, if needs be, because you can have different classes, you can cram down dissenting classes. And this process is subject to supervision of the court. The second is a new administration procedure. So it's not always going to be appropriate to have a debtor in possession procedure where a debtor has shown themselves to be incompetent or guilty of mismanagement. There may be little confidence in the management continuing to run the process. And so there's the ability to impose an insolvency office holder called an administrator who takes up the process of restructuring the company. The third is there's been a review of the winding up procedures. So these have been around for a long time under the DIFC Insolvency Law. So there's been a review of those and to make them more streamlined and to address some of the areas which were thought needed updating. And then there's been a revision of provisions to do with wrongful trading, reuse of company names, misconduct during winding up to make them more comprehensive. And then finally, and I think an audacious step by the DIFC is the introduction of the UNCITRAL model law on cross-border insolvency proceedings, which means that comity, the ability of the DIFC to work and cooperate with other jurisdictions, has been put to the forefront, and I think I would hope would enhance the standing of the DIFC in terms of becoming a place where people will want to do business and to resolve conflict as well. Insolvency practitioners play a central role in all of these reforms. So the provisions with regard to insolvency practitioners themselves have been enhanced within the legislation, and certain safeguards have been introduced, such as, for example, a bonding requirement akin to that you find in the UK regulatory regime. Insolvency practitioners are very important because they have qualifications and experience and are to be trusted to a large degree, although of course they themselves are under scrutiny through and supervision through regulation. But all of the procedures that are set out in the insolvency legislation provide for an important role of the insolvency practitioners in each case. So in the context of a CVA, for example, a company voluntary arrangement, you have the role of an insolvency practitioner as nominee in terms of critiquing the proposal that is put to creditors, and then playing the role of supervisor in terms of implementing the arrangement. In terms of rehabilitation, you have to have the support of an insolvency office holder as the rehabilitation nominee in terms of approving the proposal that is going to go before creditors and giving an opinion as to the financial wherewithal of the company while it goes through the restructuring plan, the rehabilitation plan, and also its likelihood of being accepted by the creditor body so as to avoid any sort of waste of time. You have in administration is an obvious case of where the insolvency practitioner comes into their own, where they actually take control of the company and they run the rehabilitation process. Receivership is still there as a possibility, although I understand is not used so much here in the DIFC, but it's still possible to appoint a receiver to the assets of the company. And then liquidation, an insolvency practitioner will act as liquidator in winding up, realising the assets of the company and distributing those proceeds accordingly. Rehabilitation is it's a new procedure here. In some respects, it's a sort of hybrid in as much as it draws inspiration from company voluntary arrangements, from schemes of arrangement, which have also been introduced by the DIFC through the Companies Law, and also the debtor in possession type procedures that we've seen common in the United States and France and other European jurisdictions as well. So it is there in order to facilitate the restructuring of a company, and it in some respects is similar to a CVA, but a CVA is much more limited. With a CVA, its biggest limitation is that you can't in any way vary or compromise the rights of secured creditors or preferential creditors. It only addresses the interests of unsecured creditors who are dealt with in one class, and therefore it may be a mechanism which can be used in many situations, and indeed it's very closely modelled on the English CVA, and the English CVA has had a kind of recent renaissance in the UK market with lots of you may have read about some famous sort of brands, retail chains, which have gone through restructuring processes to deal with principally with their debt on their property to their landlords. So CVAs are still there, still very much part of the legislation. But what the rehabilitation procedure does, it is, if you want, it offers more sophisticated solutions in that it extends not just to unsecured creditors, but secured and preferential creditors as well, and has the ability for one class to cram down other classes. Because it also involves a debtor in possession with the ability of a moratorium to protect the debtors, in the meantime, it is subject, in order to sort of address any imbalance, to greater court supervision. So it is a debtor in possession process. The directors can propose the rehabilitation plan, but they have to appoint, as I mentioned, a rehabilitation nominee who kind of sits on their shoulders, really, and has an important role in terms of ensuring that the rehabilitation proposal is one which is credible. The directors continue to run the company. They have the benefit of a moratorium for a fixed period of 120 days. Or 4 months, and that applies across the board in terms of creditor action. Interestingly, and again in line with the proposals in the EU directive, there is the moratorium is not just a traditional one which stays litigation and security enforcement, but it also has an impact on the contracts of the company as well, and in particular impacts on what are known as ipso facto provisions within contracts. This is a concept originally which arose in Chapter 11, which means that where contracts provide for termination on an insolvency event, the moratorium overrides those provisions, so that a creditor, a counterparty to the company in the procedure, doesn't have the ability to terminate a contract. But that obviously comes with certain safeguards to it. So this moratorium, although it's for 120 days, a creditor is always entitled to apply to court for relief from the moratorium. When that happens, the court has to do a balancing exercise between the interests of the company on the one hand and the creditor on the other, and look at the sort of relative damage to each party. The company itself doesn't have to perform all of its contracts. It can also seek to terminate those where it's not in the interests of the process. And where you have executory obligations, so where there's a contract between the company and a counterparty, and there are obligations under the contract which have not been satisfied, then the company has to provide assurance to the counterparty that they have the wherewithal to be able to continue to perform their obligations under the contract and to address any defects in performance under it. So the idea is to stop people taking advantage of the beginning of the procedure, but it's not there to enable the company to take advantage of people who have the benefit of executory obligations from the company. One of the innovations, again in line with the EU directive, is the availability of priority funding. So the company can apply to the court for funding during the moratorium process, and that funding can be provided on a number of different bases. So the funding can be provided with priority over other unsecured creditors in relation to unsecured assets. Alternatively, the court can give junior security with respect to that priority funding. In other words, where assets are subject already to security, the funding can benefit from security which ranks behind that senior security. And it's even possible to prime existing security. So in other words, to take priority over existing security, but with the safeguard that the court has to be satisfied that there's sufficient equity in the security, that the existing secured creditor won't be in any way prejudiced by the granting of that security. The model for the restructuring plan or rehabilitation plan is similar to that of a scheme of arrangement, in that there are two basic stages to the process. One is a directions hearing, whereby the debtor comes before the court and explains what the restructuring plan is, how they're going to implement it, and how they're going to constitute the classes to consider the proposal. And then the court, if satisfied, convenes the meeting of the various stakeholders, and the legislation anticipates that at least there's the company itself, represented by its shareholders, its members, the unsecured creditors and the secured creditors. And then after that, there is a post-plan sanction hearing where, provided that there haven't been any procedural irregularities, that the creditors meeting has approved the plan by 75% in value, and where there are a number of different classes, you have at least one class which has approved the plan, and that there haven't been and there are no challenges, that it's, for example, unfairly prejudicial, that it's not been proposed in good faith, then the plan is approved. There's also what's known as the absolute priority rule, which is that it's key to any rehabilitation proposal that a junior class of creditors cannot recover ahead of a senior class of creditors until they've been satisfied in full. And in addition, you have to show that the recovery under the plan is at least, if not better, than would be the case in the alternative of a liquidation. And as I mentioned earlier, there's a further safeguard. Shall I take questions? Which one to?
Just on this point,
yeah.
What is the quorum for the creditors meeting?
the actual quorum for a creditors meeting is actually just one creditor. If one creditor shows, that would obviously be an unusual circumstance. I would expect more than that to happen, but that's in the general quorum rules. Yeah. So
in that case, then can anyone challenge it later on, or the creditors who have not attended?
Well, there's an obligation on the nominee to notify all the creditors of the company. And this brings you back to the issue of voting procedures and whether or not the scheme, the proposal has been put before creditors in a bona fide fashion. So I would expect all creditors to be notified properly of the meeting. If there are a number of creditors who have been notified, and if indeed only, obviously it depends on the context of the company, but if only one creditor turned up, then that would suggest to me that there hasn't been a proper publication or publicising of the process, and there are obligations to do so.
I just want to add something on the practical.
Sure.
Normally in these kind of conditions, there's always a buy-in with the creditors, because obviously when you do a restructuring plan, there has to be buy-in. So you're unlikely to have this situation because you want them to vote for the proposal, provided it's viable. So you would always have that. You will never have this kind of unique situation, because you need to get the key creditors to support this plan. Otherwise, you won't even take it to the board.
Yeah. As Mr. Haider says, it's going back. One thing I mentioned earlier was that you need an insolvency practitioner to give a statement in support, and one of the statements in support, part of the statement in support, is that the plan is likely to be approved by creditors, and an insolvency practitioner is only going to be in a situation to do that if there's been some canvassing of opinion amongst the key creditors, and although it's not built into the legislation, if this evolves in the same way as practice does in relation to English schemes, what you normally do before going into a process like this is to get the acknowledged buy-in support, often in the form of what's called a lock-up agreement of key creditors, so that you know when you go into that process that you're going to have you'll necessarily have the majority of creditors in order to approve the process. And there are substantial downsides to going into this procedure where you don't have the support of creditors, because you could end up in liquidation. So, and certainly the debtors could very easily lose control of the company, as I'll come on to. So this is just a little sort of a flowchart to show the way the process works. So you have the application by the directors, an appointment of an insolvency practitioner as rehabilitation nominee. Company formulates the plan in step 2 and goes to the court for directions, categorising creditors for voting purposes. The rehabilitation nominee files a statement that the rehabilitation plan has reasonable prospects of being approved, so that comes back to this point about creditor support, and that there is sufficient funding for the process. Step 4 is you have the meetings of creditors and members to approve, and then, step 3 is court directions, and then we'll come on to it in a minute. If there's evidence of misconduct, then the creditors can seek to apply to the court to appoint an administrator to displace the management of the company. You have meetings of the creditors and members to approve. There's the post-plan hearing and court sanction to approve the scheme. If the scheme is rejected, then the company goes into liquidation. If sanctioned, then the company implements the rehabilitation plan, and the rehabilitation nominee may assist in implementation of the plan. That very much depends on what the plan itself has to say. Administration. So this operates through the gateway of the rehabilitation procedure, and this is where, if there is any evidence of misconduct, mismanagement, impropriety or bad faith, the court can appoint an administrator, an insolvency practitioner, whose job is to supplant the debtor's management and take control of the process. It's not on the slide, but there's also the opportunity for the creditors themselves to put a plan of rehabilitation as an alternative to that that's been put by the company. So again, there's another safeguard there, which if the rehabilitation plan is not credible, there's the alternative of the creditors putting one. And once the administrator is appointed, the administrator, he or herself, can then put their own rehabilitation plan before the creditors. And then the point of the purpose of the administration is either the approval of a rehabilitation plan, could go back to a company voluntary arrangement where, for example, there's no issue with secured creditors, secured or preferential creditors, or to use the new scheme of arrangement under the company's law, which has some similarities to the rehabilitation plan process in that you put a plan before creditors and creditors' meetings are held pursuant to appropriate classes. The downside of a scheme compared to a rehabilitation plan is because it's not an insolvency process, which is its, if you want, sorry, I shouldn't say downside. All these things only have upsides. The benefits of a scheme is it's not an insolvency procedure. It's much more light touch, and so therefore it doesn't have a cram down. If you want a cram down, you have to go through the rehabilitation procedure, but you can, through the administration, you can nevertheless use the scheme should you wish to do so. And then the administrator, and this is where the kind of prudential aspects of this part of the legislation begin to kick in, because in an administration or in a liquidation, you then get into reviewing the conduct of the directors, and you look for any challenges with respect to the more sort of fraudulent end of the spectrum, such as concealing assets in anticipation of an insolvency procedure, to transactions at an undervalue, preferences, security which has been taken for no new consideration, and so on and so forth. So we're now into that sort of realm. So really just to say that this is sort of just a very generalised slide, but as you'll see from what I've said, the focus of the new legislation is very much on restructuring. The availability of stays, debtor in possession finance, and cram down are all the key sort of features of a contemporary modern insolvency legislation. But at the same time, it retains creditor protections and the ability to investigate misconduct. Just one thing I wanted to say, I think that's me done there. Just before we kind of go over to the panel, I just wanted to pick up on the UNCITRAL model law and recognition, which is part of the legislation. Just to add there, this is quite an exciting aspect of it, because it means that the DIFC can recognise the practitioners from foreign proceedings. It's only really relevant where there is a cause to do so, because, for example, there's always been legislation within the DIFC Insolvency Law with regard to recognised companies, which are overseas companies but with a place of business here. But that's been restricted. It's still there as part of legislation to winding up companies. But what the UNCITRAL model law does, it means that you can have a recognition of foreign practitioners in foreign proceedings here, and they then get the benefit of a stay and to bring various proceedings within the DIFC. There's also the possibility of a foreign practitioner commencing procedures, insolvency procedures within the DIFC. So that means the DIFC is in a great place to assist with any foreign proceedings should the situation arise. And supplemented with that is also the ability of the DIFC courts to cooperate with courts in those other jurisdictions. So that's all to do with inward recognition. Outward recognition will obviously depend upon the particular jurisdictions that you're approaching, onshore jurisdictions, and we can sort of pick up on that in the panel session, should there be interest in doing so. So I think that sort of concludes my presentation. We could take some questions now, or perhaps it's better to do it, I think, as part of the panel session. Thanks very much.